Welcome back to the Law and Crime Network. My name is Bob Bianchi. I'll be taking it till 3 o'clock today. We got a lot on the plate, as we always do. Delanor DeMercy is a retrial. This is a boyfriend-girlfriend scenario. The girlfriend is at the centerpiece of this, and the ex-boyfriend shoots the victim in the case. The question is it a matter of self-defense? This case had been tried once before, and he testified, and it was a hung jury, although there's copious amounts of evidence in the case with respect to this. And also today, we have the Cruz hearing that we're going to be dealing with, but that is the Parkland shooting suspect, where we have 14 students killed and 3 staff members. Obviously a horrible case. But our main trial that we've been covering is out of Maricopa County, Arizona, and that's the Bueno case. This is a man who shot an officer in the face, and he is on trial, and it is a riveting case. Let's take a little look at the opening statement of the prosecution in the Bueno case. Okay, a prosecutor opening statement on Bueno. With me, I have Joseph McBride from the McBride Law Firm right here in New York City, specializing in criminal defense and a regular guest here at the Law and Crime Network. Welcome. Good to be with you, Bob. Yeah, so what do you think of the prosecution's case so far? I mean, in terms of the opening statement, it's got a lot of gravitas to it. It's an officer who really suffered tremendously and went back on the job. What do you think?
Sure. So when you think about cases that prosecutors really want to drill down and prosecute, this is the one, right? Right. The problem with this case is the identification, right? The facts are damning, they're gruesome, they're horrible. It's a worst case scenario for a police officer. Tinted window rolls down, you get shot in the face. It is, bar none, a terrible situation. But we have serious problems with regard to the ID here.
Well, you know, we were talking about this offset. Lori Richardson was one of the witnesses that the state called, one of the primary witnesses on the identification. And just so our audience understands, that's what this is about. There's a number of people in the car. It's a dynamic, unfolding situation. Shots are fired. Lori was the driver of the vehicle. And on cross-examination, she basically admitted, let out, that she had identified another male that was in the vehicle originally. And then she wasn't even gave detail, like did he have facial hair or not? Was he bald? Did he have short hair or not? And didn't she previously identify Danny, the other occupant in the vehicle? Why would the prosecution call such a witness? Because we know, one last point, from the jury questions, they were concerned by the manner with which they were asking her about how she knew about the identification.
Sure. And oh, by the way, she used meth 30 to 40 minutes before this happened, right? Not a good witness. The only logical conclusion here is it's the only witness, and sometimes you got to play the hand you dealt.
Well, you know, that's true, and that's why I'm looking forward to Bueno's girlfriend testifying, because if she could make the positive identification, and she comes with less baggage, and she's very certainly would be a person in the know because it's her boyfriend, that would be a compelling witness. That could be the only explanation to put a Lori Richardson on, though, is that if the state knows there may be some problems with that witness. Otherwise, it makes no sense.
Right. I totally agree. Sometimes you don't have options. This is your only witness. This is the only witness who's going to testify in this case, who's going to give you somewhat of what you want, some semblance of what you want. You got to use it, and you hope that the other evidence is so damning enough that you'll get a conviction.
Wow. Yeah, excellent analysis. And, you know, listen, folks, if they can't come to the fact of who the shooter is, that is a big problem for the government on such a serious case. Let's listen to the defense opening in the case. So there you go, the defense opening statement in the Bueno case. Well, you know, to the point, he brings right out from the get-go, and you want to do this, in my opinion, as a defense lawyer. Having prosecuted homicide cases for many years myself and now doing criminal defense work, you want to have something that jury can hang on to, with something so serious like a trooper getting shot in the face. And you saw the defense attorney do it right there at the end of that clip, where he's indicating somebody else was picked out of a lineup. Bad. I mean, it's got at least pauses the jury there.
Oh, definitely. And when it comes to tactics of a defense attorney, this guy is the classic professor, right? He's approachable, he's articulate, he's talking about the law, he sounds very intelligent, he's got a great personality, and by the way, he drops his bombshell in the last second. By the way, she IDs the wrong guy. Well done, polished.
Yeah, and so as a defense lawyer, do you feel tactically it's a good idea to give the jury something to hang on to? Because I know there's another school of thought that's like, well, don't say anything other than what their role is. And some lawyers don't even get up and give an opening statement, which I think is critically important to do.
Sure, I agree. I'm always on the side of giving an opening statement. I agree with you. If you can give something to hold on to, you should do it. The logic behind it is that if you give it in the opening statement, you have to deliver on it, right? So he's making a promise. He's saying, I'm going to deliver on it, and he's got them hanging on the edge of their seat, at least for the moment.
I'm interested as far as your defense tactics are concerned. If you're a defense lawyer, would you ever open up that your client is going to take the stand if your client indicated in the beginning of the case that's what they want to do?
Yes, I would certainly open up saying that in this case, you're going to hear my client say X, Y, and Z. If I knew beyond any shadow of a doubt that he was going to, or he or she was going to testify, once you say that, it's got to happen.
Yeah, it's got to happen. So I'm personally a fan. I know there's no right or wrong answer to it, but not doing that, because in a case like this, if at the end of the day, I certainly try to convince my client, if at the end of the day they cannot prove beyond a reasonable doubt who the shooter is, the only thing the client can do is mess that up when they get on the stand. And we've seen that so many times before in the cases that we cover here.
I agree 100%. In those cases, when you commit to to the defendant, your client, testifying, it's because you have to do it.
Yeah, and I don't think in a case like this you need to do that, at least from what we're seeing right now. Just curious about your point of view. Have you ever had a client in a situation that orders you to do something that you have given them legal advice to say that this is a very bad tactical thing to do?
Oh my God, of course, all the time. So when it comes to a client testifying at trial, it's the client's right. At the end of the day, the client is the decision maker. I've had catastrophic and monumental battles over this. Grand jury, a gray area. New York law anyway says that it's a tactical decision that reverts back to the defense attorney.
And you know what normally happens, folks, when those decisions go bad, even though you told the client not to do it, the defense lawyer winds up taking the heat for it anyway. Hey, we love having you here at the Law and Crime Network. We're the only ones doing all this stuff, gavel to gavel. We'll be right back. Okay, we're trying to figure out here who is the person that shot Trooper James Casey. The government is saying it's Ramon Bueno. And as we had discussed earlier, one of the state's witnesses was Lori Richardson. Now, we didn't get sound or video from her because there's a protective order by the court. But we put together a little package here at the Law and Crime Network so you can understand basically what she testified to. Let's take a look.
Lori Richardson says on the night in question, she agreed to give a few people she didn't know a ride in exchange for gas money. The passengers put a crate in her trunk and told her where to drive. When Trooper James Casey pulled them over, Richardson said her male passenger said, "I'm not going back in." 2 more officers arrived. Richardson says she heard a loud noise, and then the male passenger told Richardson to start the effing car. She says she only saw a silhouette of a gun. Bullets were flying as Richardson drove away. 2 of the passengers jumped out of her car. She ultimately abandoned her car at a vacant house. A few days later, a friend convinced her to call police. Richardson admits she didn't tell investigators the truth at first. She did name defendant Ramon Bueno to authorities, but did not directly ID him as the shooter. She did say the shooter was sitting directly behind her. When asked if Trooper Casey did anything to prompt being shot, Richardson said, no, he was actually really nice. I'm Rachel Stockman for Law and Crime.
Okay, great. Thank you, Rachel. So let's talk about this because we talked about Lori Richardson already. We can get into the substance of that a little bit after. I want to ask you the protective order by the court. Why is that happening with more and more frequency that these witnesses are being blocked from the public?
Well, for various reasons. Number one is personal safety, right? So if there's organized crime or any kind of bad actors involved who have the capabilities to marshal violence upon a person, that's certainly a reason to do it as well, a primary reason to do it. The fortunate thing is that the jury and the defendant, who has a constitutional right to confront his witness in court, get to see it. So this is happening outside of their pure view. You
know, myself and Gene Rossi, in particular, one of my regular guests here on the show, often talk about these retrials of cases that happen 15 and 18 years later where the witnesses are gone. And one of them in particular, they had detectives getting on the stand and acting out, reading the transcript from the previous trial. You lose so much of that because isn't one of the things that the judges, I don't know about New York and Jersey, they do, when you're evaluating the credibility of a witness, you look at their demeanor, their evasion in asking or answering questions, and the manner in which they testify with respect to the credibility. How do you do that when you have just a cold transcript?
You can't. The human component to testifying in court is irreplaceable. That litany of things that you just went through is absolutely on point. You got to take all those things into consideration when you're assessing somebody who's testifying. Without that, very difficult.
Well, we have another person who witnessed the shooting, William Sunderland. Let's take a look at his testimony. Hopefully it got a little bit better. Okay, so another government witness, and in case you get confused there, that is the prosecutor asking direct examination questions. Joseph, I had to actually ask the producer, is this the prosecutor? Because of the manner of the question was a little cross-examining, but you don't have to object to that if you're a defense lawyer, because the fact is, he's not really helping other than stating the obvious, that there was a trooper that was shot. What I didn't get, Joseph, was that the prosecutor's asking questions and he's saying, I don't know. Was this witness prepped? And if he was prepped, why would you ask questions you knew the witness didn't know the answers to?
Right, it's a good question. One would think that he was prepped and he's probably not delivering as the prosecutor thought, or it's possible he wasn't prepped enough. The defense attorney here has not objected. There's a lot of leading questions going on here, and I think he can see what you see and what I see, what's going on. And interesting, a question here, she tries to place him, the prosecutor tries to say, didn't you see the gunshot come out of the back left side? He goes, no, I seen it come out of the back window, which that could have came from either one of those guys in the back.
But Joseph, this is a critical part of this case where you saw the gunshot coming out from. And you know that question was asked and re-asked and asked again. And if I were the defense lawyer, I would be putting that clip up in closing and saying, did you see how the prosecutor was trying to get their own witness,
right,
the guy they called? They tried to get him to say it was coming out the way, and even he, despite all their desperation and prayerful thoughts that maybe he changed his testimony, he didn't.
Right.
And if the prosecutor can't prove that point, it proves my point that my guy wasn't the shooter. Certainly can't prove beyond a reasonable doubt he was the shooter. Doesn't that work to your advantage as a defense lawyer?
Absolutely works to the defense's advantage here. Everything you said is spot on accurate. I would play that. I would harp on that. I would hit on that round the clock in this case. My gut instinct is that the prosecutor tried to get him to overcommit with a leading question. Didn't work out. It was a gamble. They lost. Got to see what happens.
Boy, oh boy, maybe a defense lawyer takes a gamble, there's a little bit more of a risk tolerance for a defense lawyer to do it, but for a prosecutor to do it when they're the ones with the burden of proof, they're the ones that are supposed to convince 12 folks beyond a reasonable doubt on a case of this magnitude, boy, oh boy, I don't know. Cross-examination, what do we do with that? Do we say that? Do you do something like this? Did I hear the prosecutor say, give me a second here. I want to make sure I got this right. You got the jury's attention.
Right.
Did I hear the prosecutor try to get you to say, objection? They asked the question, was it coming out the window? And you wouldn't give it to them. You said, telling the truth, it came out the back. Would you go that way on cross-examination?
Without a doubt. That's exactly how I would do it.
Wow, that's going to be unbelievable because I guess we'll see what's going to happen with respect to that. So far, these are two states' witnesses that have taken the stand. What do you think the jury's thinking in this case so far? Because their minds are being formulated as we go along. We tell them to wait till all the evidence is, but we're human beings.
Sure. So I think the jury here wants to find a reason to convict, right? But on one side, think of two bodies of land with water in between them. You need a bridge. There needs to be a nexus. That nexus has to be bueno. If you can't establish that he's the shooter, you're not doing your job. You're not proving the case beyond a reasonable doubt. You certainly have not come close to doing that yet.
I'm just curious if at the end of the day the evidence comes out, if you've ever seen this in your experience. I have not. I think that prosecutors tend to be committed to their theory of the case and they're pretty intractable. If he were to be found not guilty, any possibility that they would be looking towards somebody else, although they've already made plea deals with these people, so they kind of box themselves in there?
No, they'll likely take the loss here and walk away.
Wow, that's just unbelievable. Well, guys, listen, here we are on this unbelievable case. Ramon Bueno is the defendant in the case. Trooper James Casey was shot in the face during a traffic stop. And, you know, in the training, as we've always said, there he is right there. We know that this is the number one way that officers are trained that they can be killed in high-risk scenarios like this. We got to take a break here at the Law and Crime Network. We'll be right back. All right, that's Nicholas Cruz being interrogated by the police officer in the case. Now, I got to tell you, from being a person who ran a prosecutorial agency and was in the ante room a lot of times when these interviews were being done, I really respect what this detective is doing. Now, I don't know if he genuinely consulted with a psychiatrist or a psychologist and said that, but it was a good confrontational thing to do because this could be a potential defense for him, or he could be obviously feigning this. So he asked him these questions, and it just didn't come off as believable to me in the manner in which he was answering them. What do you think?
I think we're going to come out on opposite ends of the spectrum here on this. There's a real problem with mental illness in America and across the world. And if someone is sitting there saying, I'm hearing voices, look, the guy shot up a school. That's not normal behavior, right? The guy doesn't really have a criminal record before this. It's pretty much an aberration, right? We know what he was raised, the trauma he went through. I'm not excusing, I'm not justifying. It was horrific. But when somebody's saying, I hear from demons, When somebody's saying, I hear voices, they make me want to cut myself, they make me want to kill myself, they're telling me not to trust you. And oh, by the way, I self-medicate with Xanax and weed, and he's saying things that conflict, like, I'm trying to obey the law, I don't want to do this, I don't want to do that. It doesn't sound like a logical behavior for me. It's certainly not the normal behavior of somebody his age.
It's funny, I've always said, having been a homicide prosecutor myself, that in most instances, most people don't kill like this that are mentally sound. But of course, and I don't necessarily disagree with that point of view, there's a much different legal standard that's at play that we're going to get to a little bit later on. But we're going to get to a break first. We'll be back on the other side. All right, the Nicholas Cruz case, Parkland shooting suspect. We watched the police interrogation. I thought it was artfully done because we know that there's going to be a mental health defense somewhere along the line here, either for the guilt phase, you remember it's a death penalty case, and or as a mitigating factor in the penalty phase. So, you know, good defense lawyers start that penalty phase stuff right from the very beginning in the guilt phase, from my experience, and I expect that's going to happen here. But the police did a very interesting thing here. They allowed the introduction of Cruz's brother, Zach, into the interrogation room and allowed them to talk while they were in there and recording it. Let's take a look. So brother Zach is in there hugging. I'm just curious. I mean, first off, I want a legal answer to this, and then what you think about the compelling nature of this. And it is compelling. Is there a Miranda issue here? Because when that cop said, I have to be in the room, didn't advise him about it's going to be recorded, anything that can be said between you two. I'm just curious whether they're going to argue that the brother was acting as an agent of the state. And secondly, what do you think about the impact of that testimony as you're preparing the guilt phase and the penalty phase?
I mean, it's a good question about Miranda. He's certainly acting as an agent of the state. There's no question about it. Having said that, I would want that admitted into court. I think if the jury sees that, that's probably going to be enough for the death penalty to go away.
So you think it's compelling enough because there's a lot to unpack in that, but it appears as if the kid was abandoned. The brother made believe he hated him when he didn't.
Sure. And
he really did break down when he said, I love you, and he wanted to give him a hug.
Sure. This comes from a deeply personal place for me. My brother was wrongfully convicted. My adopted brother, he has he's a mentally disabled person. If I would have been allowed into the interrogation room with him at that time, I'm not sure how different it would have been, because I had yet to fully understand the depth of his issue. That's probably the last time those two people were ever going to touch on this earth. And it's a deeply moving and deeply personal and very humanizing thing that just happened. And I think that's going to excuse him from the death penalty in this case.
Right. It is substantially, compelling information, and when you add up his age and other problems that he's had in his history growing up, that's exactly what a defense lawyer wants. Because as I've always said, folks, when the defense lawyer is doing death penalty litigation, about keeping him alive another day, another hour, another minute, and that testimony will assist the defense. We'll be right back. Okay, so the Parkland shooting suspect, Cruz, we saw two interrogations, or interrogation of a police officer, and then the brother coming in, very dramatic, and definitely will be used by the defense in the mitigation of their case. But there's also going to be some really fascinating legal arguments that are going on here. Now, I just want to set this up. As you guys know, if you get into the penalty phase, that means a capital crime has been found in the guilt phase, and then there's an weighing, an assessment of statutory aggravating and mitigating factors, and the aggravating factors have to be found, and they have to be proven beyond a reasonable doubt and accepted by all 12 jurors, and each individual juror has to believe that those aggravating factors should lead to a death penalty conviction. Of course, they've all been death qualified jurors, which means each one of those jurors said they could and would impose a death penalty if the prosecution was able to meet that burden. But there's an argument that started brewing that the defense lawyers brought up about those statutory aggravating factors, and they did that via a motion filed in court. Let's take a listen. So, Judge, what's happening here is that the prosecution is rebutting an argument made by the defense. And they've listed a number of, the state has listed a number of aggravating factors. And the defense, interestingly, wants to know which aggravating factors apply to which victims.
Right.
Specifically, not generally. And the lawyers are arguing before the judge that we don't have to give specific aggravating factors. Now, I don't know if Florida law is there. They're a little more lax than New Jersey was when we had the death penalty. You don't anymore. But I used to listen to arguments like that, and if I felt there was a problem, I would consider a superseding indictment in order to clear it up, because I knew our Supreme Court would do anything it could to find a reason not to execute. But that is not the dynamic in Florida. But what do you think of the arguments?
I think it's a good, sound legal argument, right? We're asking, as the defense is asking, look, here are the factors. You're saying that you can meet them, but tell us how you're going to do it, right? Just don't make a general argument about the overarching theme of this case. Tell us how it applies. There are 17 victims here. There's a lot of moving components at play. Give us a little bit more here. We're talking about death. Lay it out for us. Give us some kind of roadmap in good faith about how you're going to do it. I think it's a good argument. It's interesting to see how the judge is going to come out on it.
Yeah, something we were talking about off cameras. When you go to states like Florida and Texas, they were very different from like states like New York or New Jersey in terms of the evidence that's allowed, the wide and expansive latitude given to defendants. Not so much in those other states. Even in our counties within New Jersey, there were certain prosecutors that filed cases death penalty, but the same case across the border somewhere else wouldn't be filed as a death penalty. In 15 seconds or less, what do you think about the disparity of death penalty cases that way?
It's troubling. I'd appreciate a federal standard for the matter.
Yeah, federal standard, a set of unified factors that could be applied all the way across the board.
Definitely.
Certainly, and most of these cases can wind up in the federal courts. Guys, listen, you know we are at a Dan Abrams production here at the Law and Crime Network, which means we're handling it gavel to gavel. We got so much on the plate. Stick with us. We'll be right back.